Welcome back to the conference. We're just about ready for panel 2. Before we begin though, I want to remind everyone, and for the newcomers, give you some Zoom logistics. Please make sure that your mic and your video is off unless you are speaking. After the panelists give their presentations, there will be a Q&A session at the end. This is a feature on the Zoom webinar that normal Zoom does not have. It's at the bottom. You'll see it at the bottom of your screen. Please submit your questions for the panelists, and they will be asked at the end. And if you are so inclined, leave your name and affiliation. Finally, for CLE credit, if you are here for CLE credit, you need to be logged in live. CLE may ask us for our records about who has logged in, and so be sure to do that. We have been approved for 6 credits of CLE. Now I'm going to turn it over to your moderator for this session, Myrisha Lewis, associate professor at William & Mary Law School.
Sorry. Hello and welcome. We are looking forward to the housing panel. I'm just going to briefly introduce all of our panelists, and then they will proceed in the order on the program. So first we will have Professor Lisa Alexander. She is the Professor of Law and co-director of the program in Real Estate and Community Development Law at Texas A&M School of Law. Then we'll have Ezra Rosser, who is a professor at American University's Washington College of Law. Our third presenter will be James S. Burling, the Vice President for Legal Affairs at the Pacific Legal Foundation, which is located in Sacramento, California. And then our last panelist will be Wendie Kellington, an attorney at the Kellington Law Group in Lake Oswego, Oregon. And then after our 4 panelists, we will proceed to Q&A, and we will be aided by our student coordinator, McKenna Johnson. So Professor Alexander, you're our next speaker.
Professor Alexander, we've got you on.
Yeah, I'm just trying to share my screen, which is not working. So can you see it now?
No, we can't, but let me.
Okay, I'm having trouble. I don't know why. Or you can put it up if.
If you'd like to email that to me real fast, I can pull that up while you begin talking.
I did email it to you, so you should have it from me. Do you have it?
I do not. If you don't mind emailing it really fast, and that way you can start speaking, and I'll get it up as soon as I can.
Okay. Sorry. There you are, and here it is. Okay, here it is. Okay, can anybody hear me?
We can hear you.
Okay, great. Thank you. So we had some technical difficulties because we couldn't get my PowerPoint up, but I'm waiting for Allie to help with that. So first, I'll take this opportunity to say thank you for being invited. I wanted to thank Professor Linda Butler, Allie Trivet, and the other organizers of this conference, my co-panelists and moderators, for inviting me to this really great conference that's honoring the work of Henry Smith. So I'm really happy to be invited. I did have a PowerPoint that I wanted to show. I don't think it's up yet, or at least I don't see it, but I can tell you what I'm going to talk about as I'm waiting for it to come up. So this panel is really about whether or not there's going to be a US housing crisis and what solutions, if any, there might be to solving this crisis. And I am submitting that we are on the precipice of a pretty major US housing crisis in 2021, if not sooner. And so I had slides to show, see if Mary's got them up.
I'm sorry, I still don't have them.
I know. I don't know why you can't share my screen. Let me try sharing my screen again. My screen. Yeah, I don't know why. It's maybe because it's in my browser. You still didn't get them from my email?
No, unfortunately, I didn't.
Maybe you can let go.
Next, and
yeah, maybe you can let another speaker go until I can resolve this with you.
that sounds great. We will move on to Professor Rosser. Give us just a few moments to switch over. We'll take just a minute break while we're waiting for Professor Rosser.
I'm here. Can you hear me?
We can hear you. Yes, Professor Rosser. Do you mind taking over a little early?
Yes, no problem.
Technical issues. Thank you.
We'll do that right now. Sorry, I'm just going to load the screen and share. Okay, can you see the screen?
Yes, we can. Perfect.
Great. So thank you so much. I'm sorry to be the takeover right now. I will say, as far as a brief introduction, many of you I know, but I teach property, poverty law, federal Indian law, and sometimes housing law. And now, because I'm bad at negotiating with the dean's office, wills, trusts, and estates. Why I want to start just by saying why I'm here, and then I'm going to get to the substance. I'm here largely because of Eric Clays. So some of you know Eric. And just before tenure, I noticed that on every panel, it seemed as if there was a normal person, and then Eric. And he seemed to be the sort of token invitation by a conservative, by the vast blob of well-meaning progressive conference organizers invited. And whenever I heard Eric, I thought, I love what he's saying. I disagree, but I love it. And I immediately liked his stuff. I thought to myself, I need to escape the blob in the same way Eric did. And I thought that if Eric could be the token conservative speaker, I could be the token crazy left speaker. Now, I fear a little bit that position has been taken. Thomas Merrill just said that he was the wild-eyed radical, and I was really looking to have myself be that person. But I decided to start writing as if I wanted to write what I actually felt, as opposed to just writing to sound smart, which is a luxury you get after tenure. And so I wrote a couple of articles, both sort of attacking different groups, but largely putting out that we need to take acquisition and distribution seriously, or more seriously than I thought it was being taken by most property people. And then, frankly, I got depressed. After my second article came out and fell just completely flat, I shifted my attention back from property to poverty law and a long neglected Navajo economic development book, land use book that I'd been working on, which is why I'm really excited and honored to be invited, because I was afraid people might have forgotten about me. So what I want to talk about today is what a radical vision of what zoning might look like. That's what I'm going to focus on. My only sadness before I get started with this project, and I do experience this as sadness, is that for reasons that I'll now turn to on matters of zoning and affordable housing, I think conservatives got it right. And you don't know how much pain that causes me to say that. Another way to put it more positively is sort of in line with what Henry Smith started us with, which is this represents an opportunity to overcome dichotomies. I will now turn to my larger argument, which I'm here presenting as just a series of acknowledgments of the works of others. So on zoning and the cost of housing, I first want to acknowledge Robert Ellickson's recent works, one about Silicon Valley, New Haven, and Austin, and then the related piece about the zoning straitjacket. I chose as the image here Woodbridge because I painted houses one summer in Woodbridge and was just astonished by how little housing they allow so close to New Haven. So Robert Ellickson's pieces do a great job, I think, identifying the problem and proving the problem, right? Proving that zoning is limiting development in severe ways, and limiting it in ways that lock in advantage to those who buy into a single family home neighborhood. Another piece that's worth celebrating is the recent, very short, so I highly encourage people to read it, Vicky Bean and others writing about supply skepticism. Now, the article, my only critique on the article is it sort of pulls its punches. It says supply skeptics have somewhat of a point, but the empirics don't back them up. I think if you read it, though, with just a little bit of attitude, you will see they're really saying that supply skeptics should be quiet, right? That supply does help people. And in particular, and this is the most important, I think it shows that supply increases help even the disadvantaged. So I teach poverty law. I am a co-author of one of the poverty law textbooks. And that really matters to me, that sort of empirical investigation of whether these new units are going to hurt the poor or help the poor. They make a pretty good case, I think, a pretty convincing case, that it doesn't do bad and it most likely will do good for poor and poor minorities. And those articles were ones, basically, my first part of my article largely is in agreement with them. And then I moved to another characterization of this that I both agree and disagree with. So that is the new piece co-authored by Sirkin. And they identify the point that I came to as well, which is it's quickly becoming liberal orthodoxy to promote density by removing zoning restrictions. Again, to go back to the previous slides, I think that Ellickson and now Bean deserve a lot of credit for that. It also, credit goes to Obama, who did a report, and that report came out largely in favor of reducing land use restrictions. The challenge with this is the language that Sirkin has here, the elite libertarian consensus, right? For me, an elite libertarian consensus, you could just feel the sort of pain. But then after reading more of it, I decided I didn't care that much about the pain. I am happy to join in this elite libertarian consensus if that's what it required. And more broadly speaking, I think there is value in recognizing and taking advantage of when we have a coming together of different camps, right? So Henry Smith in his talks talked about these dichotomies and how they lead us to a sort of false sense, and I think a false antagonism. I'm guilty of this too, right? My only article that people actually read, I attack the left on the left. But that being said, I'm really interested right now in that sort of middle ground where you can have conservative property scholars and progressive property scholars maybe coming together in concern about over-regulation of land use and how are we going to deal with the affordability problem. And it's affordability not just for poor people, but in these dynamic cities, as Sirkin talks about and others, it's across the board. And so on the left, I think there's a need for humility and an acknowledgement of having been wrong about sort of neglect of zoning overregulation and land use overregulation. Humility is a hard thing to do. I think liberals on the whole side of the left spectrum have been guilty of fighting some of these fights for the in-group, but not concerning themselves with groups that may be wanting to enter that neighborhood. And on the right, my view is that there's also a need for humility. And this will sound a little bit too nasty, I guess, but conservatives have used these tools that these liberal ideas are going to hurt the poor as a dramatic sort of sledgehammer against policy that progressives favor. And that's all good as long as once progressives come on board, we actually see that it wasn't just a rhetorical tool, but it was instead actual concern for the poor and those left vulnerable by our current zoning policies. So I think on both sides, in order for that coming together to happen, to overcome the dichotomies as Henry Smith talked about, we need to recognize both sides need to be part of that coming together. Though frankly, perhaps the left needs to do more on this. So it's worth talking just briefly about what am I concerned about. Obviously, one we've heard a lot about was Euclid, and Ellickson's talk also mentioned, the sort of the justice's version on apartment houses and the way that apartment houses are looked down upon, and is really looked down upon for a lot of reasons, some of which you may value, but it ends up locking in advantage. And then we have, I think the challenge is there have been some improvements. There's a younger version of me in front of the Ethel Lawrence homes, but they're very slow, right? So even Mount Laurel resulted in change, but only over a very long time horizon and very marginal. Even if you drive through Mount Laurel today, and this was actually 3 years ago when I did it, but I saw signs saying this lot preserved in the interest of the environment, right? And what they were doing was trying to use environmental protection as a way to freeze out more density. And then Nestor Davidson has a new article that I think is great on this. And his point, and one that I share in my paper, is that there is some leverage there, and we saw this in Mount Laurel, that the use of the general welfare could be a way for states to reclaim authority. Now, Nestor's paper does, in a similar way to his earlier numerus clausus principle, it walks a fine line sort of between camps, and in this case, trying to say how general welfare can be used to do good things, but it will also not allow you to do bad things. I think it's a hard case to say. It's sort of like Cristina Rodriguez's sort of celebration of state authority over immigration matters. It may work in some cases, it may work not, but I think he makes a good argument in favor of use of the general welfare. But then I want to move from his to some of the other people, and frankly, this is another of the depressing parts about when you do research. You have an idea and you think, I'm going to run with this, and then you discover other people have run in the same direction as well, and so and have done a beautiful job. So the first one is John and Franca, who has a couple of articles. I first read John and Franca for the micro unit stuff and stuff related maybe to what Lisa Alexander is going to talk about. But then his other more recent article on land use preemption amid the housing crisis, it's a very California-centric, right? And anybody writing about this, there's a new book called Golden Gates, which is also very California-centric. But that makes sense because they're having somewhat of they're the place where we're seeing the demand for these changes and seeing some political will for these changes, even though so far it's been shot down by the public. Another great article on this is Anika's Limar's article on, and she tries to find places where states have successfully preempted local zoning. And there are some of which I certainly hadn't thought of before. I had thought of the manufactured housing and knew about that, but I didn't know about the daycare one that she talks about, nor group homes. She brings us and says that when there's the right combination of sort of vested interest that wants straight preemption and a recognition, and it can be that vested interest could be monetary interest or just a state bureaucratic entity, then we can make progress on some of these things that seem otherwise intractable and subject to this local dominance on zoning. So that's the sort of lead up to where I'm at. And then sort of the last bit of my paper, I'm going to talk about what does this mean as far as where we should go forward. And my answer is a regional one. Now, there's a lot of problems with the regional one. And I will say in the paper, I try to carve out some sort of BS that allows me to say regional or state. But I think ultimately the next move for the next century of zoning should be a move towards regionalism. Now, the challenge with this, as anybody that's done local government has looked at, is that there have been lots of different proposals for regional zoning and a greater regional approach to different problems like affordable housing. And they often don't go anywhere. So Cheryl Cashin, in her article from 2000, identified that transportation, we do see regional agreements, but we don't see them so much in other zoning spaces, especially for affordable housing. The one counter to this, I'm on the board of the Fairfax County Housing Authority, and it was great to see, Trump came out with an anti-affirmatively furthering fair housing rule. And in response, the neighboring housing authorities came together to do a collective work on that. They're not required to anymore under the Trump administration, but they're still going forward with it, and they're doing it in a regional way. So I know I'm short on time. I will end just with a couple things. One is, why does this matter? I think we saw in some of Trump's tweets recently that it's not that there is a threat that some people feel. And I know that it's easy to blame Trump, but I think this is true for a lot of people. When they're seeing apartment buildings or they're seeing demands placed upon them, they don't want them, right? So I do think this, though it's easy to dismiss things Trump says, I think this is a fair point. It's one I completely disagree with, but I think it speaks to some people's fear, and so it matters, right? That's my larger point. The last thing is later on, we're going to have a panelist from the Pacific Legal Foundation, and just to echo that I feel nervous about even saying all these things, I never agree with anything from the Pacific Legal Foundation, except perhaps here. And I think that that's exciting. If we can find places of agreement, then arguably we could make progress on really pushing back finally on local dominance of zoning and moving towards a regional or state solution. So thank you very much, and I will turn it over.
Jim, if we could have you go next.
Excellent. I'm trying to come on. I think I'm on the screen now. So let me begin with the astonishing admission that I may be agreeing much more with Professor Ezra Rossiter's statements than I, as a libertarian conservative, would like to do. But representing landowners for the last 35, 38 years, I've come to have a strong distrust of government regulations that prevent the building of housing. And what we do as a public interest law firm is try to bring the stories of people that are hurt by the wheels of government bureaucracy to the attention of the courts. So I'm going to begin with stories. These are not our stories. This is a story on the history of zoning. And I want to take you back long before I was alive and before Pacific Legal Foundation was the gleam of an idea of his bad conservative minds. This is summer of 1910, where a successful Yale-educated attorney named George McMechen and his school teacher wife moved to a nice, prosperous part of Baltimore called Utah Place. Immediately, all hell broke loose. There is a petition that was circulated among the good people of Baltimore to, quote, take some measures to restrain the colored people from locating in a white community and proscribe a limit beyond which it shall be unlawful for them to go. This was 1910, of course. Now, there was a lot of opposition. There was white opposition, there was black opposition. The Baltimore Afro-American newspaper spearheaded a lot of the opposition, saying we're opposed to it not because black people, and I'm quoting, necessarily want to move into white neighborhoods, but because segregation was anti-American and mischievous. So the town of Baltimore, city of Baltimore, did pass the statute where, and I quote again, quote, that no Negro can move into a block which is more than half of the residents were white, and quote, that no white person can move into a block in which more than half of the residents are colored. I suppose that was anti-gentrification of the era. And the law had teeth. It said that a violator of the law is punishable by a fine of not more than $100 or imprisonment for 30 days or both. There's a party line vote, Republican versus Democrat, in favor of it. The Democrats carried the day, and it was passed. This, of course, the era past the Reconstruction, and the Republicans were much more opposed to the Southern ways of doing things than the Democrats were. This was despite the fact there was some opposition and some roadblocks put in the way of this, it eventually, after a few amendments, was the law of Baltimore. And the idea spread like wildfire across the South and the border states. In 1914, it landed in Louisville. And Louisville had an ordinance to prevent conflict and ill feelings between the white and colored races in the city of Louisville, and to preserve the public peace and to promote the general welfare by making reasonable provisions requiring, so far as practicable, the use of separate blocks for residence, places of abode, and places of assembly by white and colored people respectively. Now, there was much opposition to this as well from the white real estate business interests, and of course the newly formed NAACP, which had its 5-year-old chapter in Louisville. And at a meeting at a local black church, Chaplain Brinsdale, NAACP's lawyer who came in from Washington, D.C., told the crowd that the results in Louisville will be of utmost importance in determining whether or not the Negro is to be segregated. It will not be easy to avoid the ordinance in the courts. Louisville has drawn its ordinance very carefully. Now, William Worley was the first president of the Louisville branch of the NAACP. Charles Buchanan was a real estate businessman. He was white. And together they hatched a plan to challenge the law. And so they entered into a real estate contract, which had a very unusual clause. And this is a testament to what I think is the brilliance of the legal strategy of the NAACP at the time. A quote from the contract: it's understood that I, Worley, am purchasing property for the above purposes of building a home, I'm paraphrasing a bit, in which I propose to make my residence. And it is a distinct part of the agreement, quote, that I shall not be required to accept the deed to the above property or to pay for said property unless I have the right under the laws of the state of Kentucky and the state of Louisville to occupy said property as a residence. So that was the way, because when Worley signed the contract to build the property, he then said, I'm not gonna pay you for this. I'm not gonna buy it. I'm backing out of the contract because I can't live in this house in this block. And so Buchanan sued Worley, and it said they knew exactly what they were doing. And you would think, of course, the logical starting point of a challenge at that time might be something like the Equal Protection Clause, but it was the wrong time to bring a challenge under the Equal Protection Clause. Plessy versus Ferguson was a few years back in 1896. And in 1908, only 6 years before the statute in Louisville was adopted, there was the Berea College versus Kentucky case. And this is a case where a long-time integrated college was forced to kick out all of its black students because Kentucky had passed a segregation Jim Crow law that forbade the education of black students and white students, even at a college, in the same classrooms or even the same college itself. And that was upheld by the Supreme Court. Well, they punted on it. They could have gotten to the merits, and they avoided it, so the lower court decision out of Kentucky was upheld. But the NAACP in Kentucky, challenging the Louisville Ordinance in Buchanan versus Worley, realized that they had something that they could work with, and that was Lochner, the much since derided case of Lochner and its respect of economic rights. And so the NAACP crafted a strategy where they're using the property rights of the owners. Now, the NAACP wanted to make sure that it could win in a very difficult court where it was basically dominated to a large degree by very traditionalists and whites, of course. And they wanted to make sure nobody would be very afraid of a ruling in favor of the challengers to the ordinance. So the NAACP brief to the Supreme Court has some language in it that I have to give a trigger warning for this. It is pretty, it's pretty hard to listen to this, but it's important to know the situation that they were in at the time. And so here is the language that I think is very, very troubling, but which they felt they had to put in. That if the ordinance in question is enforced, it will result in preventing the better and more prosperous element of the colored inhabitants from obtaining residence in a better locality. Because if they can't do that, they will be forced to, they can't improve their condition and will have to, quote, move to undesirable quarters of the city where they and their offspring will be constantly thrown in close touch with and contaminated by the degraded and worthless class of Negroes, end quote. And I'm sorry, that just makes me cringe when I hear that, but that shows what they were up against in trying to challenge the racial zoning. And so to their credit, they said they rest our case not upon the idea of mixing the races together, but in the fundamental principle that while a state may make police regulations which forbid many acts which would otherwise be lawful and may add restrictions respecting the use of property to those existing at common law, that you cannot have restrictions, the restriction must affect all citizens without discrimination. And so the decision that overturned and struck down the racial segregation zoning in Louisville and the rest of the country was based on property. And the court said property is more than the mere thing which a person owns. It is elementary that it includes the right to acquire, use, and dispose of it. The Constitution protects these essential attributes of property. Property consists of the free use, enjoyment, and disposal of a person's acquisitions without control or diminution save by the law of the land. And we think an attempt to prevent the alienation of property in question to a person of color was not a legitimate exercise of the police power of the state and is direct violation of the fundamental law enacted by the 14th Amendment of the Constitution. So property rights were the key here to respecting the ability of people of all races to acquire property. Now, that was in 1917, but 1924, the Supreme Court looked at the 1926, the Supreme Court looked at the ordinance in Euclid, which is zoning. It was exclusionary zoning, but it was not racial zoning on its face. Now, the trial court tellingly struck down the ordinance. And the ordinance said, look, we understand that the true object of this ordinance in question is to place all the property in an undeveloped area of 16 square miles in a straitjacket. The result to be accomplished is to classify a population and segregate them according to their situation in life. And then the court goes on, it says, you know, we know that the next step in the exercise of this police power would be to apply similar restrictions for the purpose of segregating in a like manner various groups of newly arrived immigrants. Now, another quote from a case that should have a trigger warning on it because it is highly offensive, but here it goes. This is what the law was in 1924. The blighting of property values and the congesting of population whenever the colored or certain foreign races invade a residential section are so well known to be within the judicial cognizance. And so what the judge was essentially saying here, the trial court judge, was, look, if Buchanan was struck down for the very noble purposes of segregating neighborhoods by virtue of race, certainly this segregation by economy in Euclid has to be upheld. Well, the Supreme Court didn't agree with that, as we all know, and this is the famous case of calling apartment buildings nuisances, as Robert Ellickson referred to earlier. Nuisance may be the right thing in the wrong place, a pig in the parlor instead of the barnyard. And he talks about the development of coming of apartment houses, which has resulted in destroying an entire section for private home purposes, that in such sections are very often the apartment house is a mere parasite, et cetera, et cetera. So the idea that the people moving into these apartments would create crowding and traffic, and worse than anything else, you would have to be rubbing shoulders with people of a very different class and ethnicity. And so Euclid, I'd like to say that what was born in Baltimore, that died in Louisville, was reborn in Euclid, just by a more whitewashed way. Euclid was a gateway drug to exclusionary zoning and hardcore NIMBYism pretty much everywhere. So we know the impacts that excessive land use regulation has had. You know, in January last year, there were 570,000 homeless people. It's roughly the population of the entire city of Albuquerque. Of those, 212,000 were unsheltered, a euphemism for their living in cardboard boxes and tents. The western cities, homeless has been increasing in double-digit numbers every year. Once there was we have in California 151,000 homeless, and the statistics go on and on. California has a shortage of somewhere between 1.4 and 2 million housing units. There's a need to build 200,000 a year, but in a very good year, we build half that number. Over almost half of Californians are cost burdened, and it goes on and on. The impacts of excessive land use regulation are clear. Now, the idea that we've gotten over segregation in housing hasn't exactly died. Jimmy Carter, when he was running for president, says, I have nothing against a community that is made up of people who are Polish, who are Czechoslovakians, who are French Canadians, or who are blacks trying to maintain the ethnic purity of their neighborhood. This is a natural inclination. Now, he walked that dog whistle back, but it was out. It was clear where he stood. In 1991, a commission on affordable housing said millions of Americans are being priced out of buying or renting the kind of housing that they would otherwise could afford if not for the web of government regulations. And it says in 24 years, we've had 10 studies talking about this, and nothing's been done. That study was in 1991, and of course, in the subsequent 30 years, we've done virtually nothing. The Obama White House, as Professor Rossiter referred to earlier, talked about this problem. Local policies acting as barriers to housing supply include land use restrictions that make developable land much more costly, that is inherently. Zoning regulations, off-street parking requirements, arbitrary or antiquated preservation regulations, residential conversion restrictions unnecessarily slow the permitting process. Now, President Trump initially agreed with that, but then he much more recently had what I think is a very unfortunate and reprehensible remark talking about the Biden campaign. They want low-income housing. And I'm quoting, he gave a little talk on Fox News, and with that comes a lot of other problems, including crime. You have this beautiful community in the suburbs, including women. And the response, this is in response to a question about what he's doing for women and getting their vote, including women. They want security. I ended it where they want to build low-income housing projects right in the middle of your neighborhood. I ended it. If Biden gets in, he's already said he's going to do it at a much higher rate than ever before. And you know who's going to be in charge of it? Cory Booker. That's who's going to be charged. That's going to be nice. I mean, that's his worst dog whistle that I think we could possibly hear from anybody in power. I find that actually to be a rather disgusting remark. We know that excessive land use zoning is the reason behind a lot of the housing shortage. In California, this book called The Zoning Game Revisited that came out a few years ago, there's a quote in there that talks about why would a developer in California bother challenging the ordinance when it would be, and I quote, when it would be simpler and cheaper if he simply cut his throat. Building in California is notorious, which is why we have some of the worst housing situation in the state. I think if we're going to talk about ending homelessness and housing shortages, we simply have to build more housing. Yeah, it's a supply issue, housing of all kinds. But to do this, I don't think the answer is to add more government regulation and control. Whether we're shifting it around from the local to the regional level, I think we're going to end up with the same problems ultimately. Instead, I say return rights to the landowners that were taken away in Euclid and subsequent legal decisions. Let people build on their land what the market requires, what the market demands. And if somebody wants to build a 4-plex or a 5-plex on a half-acre of property, more power to them. And I hope that people on the left now, instead of opposing it when we try to defend property rights, will help us defend property rights in the courts of people trying to use their property for reasonable non-nuisance purposes. Thank you.
Thank you so much, Mr. Burling. We will actually have Professor Alexander go next.
So I'm trying to share my screen now. I think it might work. You all can let me know if you can see it. Can you see that?
We can see it, yes.
Great, excellent. Okay, well, this worked when we tried it in the practice room, and then we got in the main session because of how I got in. I couldn't get up, but I'm glad that I'm able to put my PowerPoint up so that I can somewhat slightly disagree with my prior two panelists. So I'm talking about tiny homes for the homeless. And in, I think, November of 2019, I published an article in the Minnesota Law Review titled Community and Property: Lessons from Tiny Homes Villages. And the question that this presentation really explores is, given that I believe we're on the precipice of a major housing crisis, is there any role for tiny homes movements? And if so, what does that mean for law and property theory, if there is? So first, my assertion that we're on the precipice of a housing crisis. There was something called the CARES Act, as everybody probably knows, that was put into effect in light of COVID-19, and it expired on July 25th. It provided approximately $6 trillion of direct and indirect federal aid for housing, but those protections ended on July 25th. And scholars at the Eviction Lab and other places predicted that approximately 20 million to 28 million people might have been facing eviction between July and September alone, right after the CARES Act protections against eviction and some of the protections against foreclosure may have been expiring, especially the eviction protections. Notably, the last major housing crisis that we had was in 2008. And at that point, about approximately 10 million people were displaced from their homes through foreclosure or eviction over the course of about 10 years, right? So the 10 million people was over 10 years. What we were talking about in July and September was 20 million to 28 million people in 2 months. So it would be on a much broader scale than what we had experienced even in 2008. One of the things that prevented that, of course, was that the Trump administration, through executive order, put forward an eviction moratorium, and the CDC actually put that forward. And it took place on September 4th, and it applies to people who make individuals who make about $100,000 or less than $100,000, and joint couples that make about less than $200,000. And whom are experiencing some kind of hardship due to COVID-19, inability to pay rent due to COVID-19. They have to do a lot of things to be able to avail themselves of this, but this eviction moratorium probably staved off or suspended the problem that I think will be before us in 2021 in terms of evictions and displacement of individuals, right? So we haven't seen the effects right now, but I think they're coming. So even with the Trump eviction protections, there's efforts to sort of see the hodgepodge of state, local, and even with this federal protections, the hodgepodge of different eviction laws and rules and things to keep people in place. And even with all of this federal protection, at least in 17 cities that the Eviction Lab at Princeton University has tracked, there were 53,579 evictions during the pandemic. And even in a week after the moratorium was enacted on September 4th, as of September 26th, there were 2,305 evictions in those 17 cities. So even with this, we are still seeing some level of evictions, and I think it foretells a housing crisis that is before us. So what does that have to do with tiny homes? Well, in my article, I talked about and provided a typology of tiny homes villages for unhoused people in 39 of the 50 states in the US. And these were efforts that were kind of public-private partnerships, individual self-help efforts where individuals set up tiny homes villages of formerly homeless individuals. Tiny homes are homes and dwellings that are less than 400 square feet. And some of these dwellings that in the villages I studied were 99 square feet. It could range. And under most state and local building codes, right, that is below the definition of a dwelling, right? So they're basically homes that don't necessarily meet the definition of a dwelling unless there's been some kind of zoning change. And what I was interested in the article was looking at the sort of housing villages and the ways in which people utilize tiny homes, unhoused people, formerly homeless people, utilize tiny homes in co-housing relationships. And I thought it said a lot about some of what we discuss about what constitutes property in property theory. So in my discussion, I basically came up with a couple of different concepts. One was some of the villages that I studied had a structure that I termed stewardship, meaning many of the formerly homeless residents were allowed to be in their units without having paying rent at all. And by building their units themselves or building the units of other homeless people who were on the particular village or site, and being able to steward and have a right to remain in that space, having a right to exclude others from that space, but also having obligations in that space. And some of these villages were permanent, like in Madison, Wisconsin, that I wrote about in the article. Others were temporary, like in Seattle, Portland, Eugene, Oregon, where some of them were you could be in there for about 2 years. It was more seen as transitional housing for formerly homeless people. And then there were other units which were rental, using a traditional rental structure, but in a kind of co-village situation where certain features of the village were shared. Shared bathrooms in some cases, shared common spaces and kitchens, shared community resources like gardens and other things. And finally, in Detroit, Michigan, they took an effort where they used tiny homes, which were a cost of $1 per square foot. And usually the tiny homes were about 300 to 200 square feet. So about $250 to $350 for people to rent these homes on this particular site in a blighted area of Detroit. And then if you remain in the community for 7 years, you then get a right to own. So I was interested in these, and in particular, what I was interested in as property theory, as it relates to property theory, is this tendency towards something that I called stewardship. So I asked if stewardship was a new housing tenure. And I argued in the article that stewardship provides the benefits of home ownership without ownership, and in some cases without even the formal status of renting. It's a property use arrangement and a contractual arrangement that gives stewards, these are people who aren't, in most cases, even paying rent, some of the social and economic benefits of home ownership without the status of ownership, right? So they are able to exclude, they have the right to exclude people from their particular tiny home unit. That is a huge and important right for many formerly homeless people, particularly if they've been in domestic violence situations and other situations. The right to exclude is important, but you can't get that right to exclude unless you also engage in the obligation of community participation and co-management. So many of these villages required the people who were participating in them to come to community meetings, to make some kind of sweat equity contribution to the construction of the village and its maintenance. And they tried to have many different kinds of things at the village that would allow for community participation. And that was a requirement. Like, you couldn't get your right to use or exclude unless you also did these other things. So stewardship gave the occupant a right of possession for a specified time period and a right to exclude as long as the steward provided sufficient sweat equity hours and complied with the terms of the common interest community contractual agreements. This was really interesting to me, and here's an example of a tiny home in Madison, Wisconsin. This was permanent stewardship, where they didn't have to pay rent and could stay there for as long as they wanted, as long as they were complying with the terms of the agreement and providing a sufficient amount of sweat equity hours. It was about 60 sweat equity hours, I think, were required. And as long as you're doing that and you're not violating the community rules, some of which were, you can't have substance abuse, you can't bring things onto the community that would cause crime or other problems. But if you could comply with that, you could be in this village for however long you wanted to, as long as you're following the rules without paying any money or any rent in the traditional sense. Also, there were opportunities to work in, works that you could provide to the broader community within Madison. So there was woodworking projects that they sell. They had garden beds for food production. They had a shop store, which they would use to make the tiny homes, but also to make these other artisan artifacts. And so I was really interested in how people were sort of using self-help in this interesting way, but also kind of formerly homeless people were getting some of the benefits of ownership without the status of ownership, without even the formal status of renting, but they were able to exclude as well as able to share in ways that were important, as well as develop new skills that help them participate in society in a meaningful way that many of the residents found meaningful. Interestingly, in Seattle, they did a similar thing, but this was temporary stewardship, where you have formerly homeless people who they basically came up with a form of zoning which recognized temporary transitional homes as a category under the zoning code. And then Seattle, in combination with nonprofits and public-private partnerships, would have a series of different tiny home communities throughout the city, some of which had different rules, some of which the land was city-owned, some of which it was privately owned, some of which a church owned it. But they had many sites throughout Seattle, Olympia, Tacoma, and Washington in which people could stay for up to 2 years, but they weren't required to stay for a period of time, but they could only stay for up to 2 years. And many of the same requirements that I described with permanent stewardship were also required. You had to go to community meetings, you had to participate in some meaningful way to the community, and you also had to not violate the community rules, which in most villages required you, to not be using drugs on site, to not be involved in crime or anything that would sort of undermine the value of the village. There were a couple of villages which did allow that. There was a lot of NIMBYism responses to the villages, which did allow sort of substance abuse using housing first approaches. But many of the other villages have been there for a while, and there is some NIMBY resistance, but not perhaps as much as one would think. What was important was that they zoned this, right? So this is an example of government regulation actually contributing in a positive way to supply, because they are coming up with zoning designations and categories. Some of them are exceptions to the zoning code, but in this case, they actually voted in, this was a part of the zoning code to allow these types of villages and these types of structures. Now, I saw recently that Seattle was expanding this to use these homes in the fight against COVID-19. So individuals who are vulnerable from getting sick, who are homeless and vulnerable to getting sick from COVID-19 can participate in the tiny homes that have been established through the city's public-private partnership. And they're also putting a priority on referrals of Native Americans, Alaskan Natives, African Americans, and others to prioritize those, because some of the other villages that Seattle created, one of the problems was they were not as diverse. They were predominantly white, and they're making an effort to have some diversity and inclusion right in this effort. So what's this have to do with it? What I think is interesting about property theory is that stewardship sort of modifies the right to exclude by combining it with an obligation to participate in a community for human flourishing reasons rather than profit-making or short-term wealth maximization. So you don't have a right to alienate or sell. You don't have a right to give this to your children. This is not something that you're using to build wealth per se, but individuals can use it as a way of providing shelter, as well as providing a foothold into a community that helps to advance the members' human flourishing in interesting ways. And you do this without the status of ownership and without necessarily the status of renting. I think it's interesting because it deviates from the essentialist prototypes of ownership and renting, yet it finds ways to maximize efficiency as well as advance equity and access for groups facing uncertainty and precariousness. And that's what I argued in the article, that in many ways, it's more efficient for the city, if they can bring this to scale, to build these for numbers of people facing uncertainty, because the homes are small, they cost less, you can put them up quickly. It can be efficient in certain ways than perhaps just the regular affordable housing process, but it yet advances equity and access, and it also gives homeless individuals who seek it or want it the opportunity to be involved in their own self-determination and co-management. So this is another example of another community in Austin, Texas. This one has a traditional rental structure. Of course, the rents are less than the regular market rents that one would pay, but they use a more traditional structure. The only reason I wanted to mention this is because this has taken the idea to scale. So they have about 250 formerly homeless people, men and women, live on this very large site outside of Austin. Now, for those of you who are criticizing zoning, it's outside the bounds of regular zoning. So because it's outside of Austin, there were not a lot of zoning rules that precluded the ways in which this community would be structured. But with the help of a sort of faith-based effort, they were able to take the tiny homes idea to scale. So there's 100 RV park homes, there's 130 micro homes, there's laundry facilities, outdoor kitchens, community art house. There's a community cinema where the formerly homeless residents who live there can invite people from the general Austin community to come to the site, and they provide, services, concessions, show movies, and it's a way for people to be involved in work in interesting ways. There's also a community inn where non-homeless people can come stay, like an Airbnb and a bed and breakfast, and participate in this community and stay overnight and provide money to the community if they so choose. There's many other things there, but I just wanted to show how this could be taken to scale in useful ways. Okay, and finally, this is an example of Detroit, where they use a much more traditional model where the individuals rent the homes. Each home is on its own lot. There are not a lot of community requirements or community participation requirements, although they're trying to foster a voluntary sense of community between the residents who live there, right? So here's the final point, because I'm probably getting over my time, is that I think this idea is a way to address the supply problem that many of my prior predecessors on the panel were talking about. But it's not a completely deregulatory, no zoning involved solution. And it's one that I think can be applied outside the context of formerly homeless people. So in California right now, there have been so many fires and so much displacement due to disaster relief or climate change that this is actually an idea that might have some footholds. In Chico, California, in fact, in the face of a disaster, they did use tiny homes for displaced people to stay for a temporary period of time. You might not just do it for homeless people, you could use it for people who are displaced. And you could use the stewardship version of the model where individuals don't have to pay rent because they're trying to deal with the expenses associated with perhaps their more traditional property. But this could be a temporary way in which they contribute to a constructive community in light of the uncertainty and tragedies they face. I think there could be public health housing alternatives like the Seattle example. It has been used a lot for veterans, common interest communities. And I also think there could be gentrification and displacement alternatives, especially in the light of the mass set of evictions that I think might be before us. They could be combined with community land trusts, with transferable development rights programs. I think there's all kinds of possibilities, but for property theory, I think what's interesting is that many of the behavioral benefits of ownership, having a sense over your place, a responsibility for your place, being connected to a community that furthers your human flourishing, being able to exclude, but also having to combine that with the right to include and be part of an inclusive community are really interesting and raise questions for what it is that we mean it constitutes property or not property. The idea that there's other forms like stewardship that might be really useful in the face of uncertainty, I think is something that we should discuss more in the future. So that's a wrap.
Thank you so much, Professor Alexander.
Okay, so I have to stop sharing.
And we'll have Wendie Kellington come on next.
Good morning. My name is Wendie Kellington, and my focus is to talk about solving the housing crisis with non-traditional ideas, sort of along the lines of Professor Alexander's ideas, but perhaps a bit more radical to most. I have provided an abstract in your materials, and there is an image of sort of the idea that I think about at page 8, and that's an image of a facility that rich white folks have established for themselves in Las Vegas because they do not desire traditional housing. And it supports my idea that we don't need to provide traditional housing to all of the populations of homeless people in order to solve this problem. So the premise of my talk is to identify that in order to solve the crisis of homelessness, we have to do 3 things. We have to acknowledge the differing people who experience homelessness. We have to acknowledge that traditional housing for all of those populations doesn't solve the crisis because many of those people do not wish to or are simply unable to live in any kind of a traditional facility, whether it's a LEED certified multifamily facility or a government sanctioned tiny house community. There's a large segment of the homeless population that is incapable of following the rules and will be kicked out. And we must be willing to embrace solutions that include otherwise homeless people living in adequate circumstances that the housed may not find appealing, and perhaps tailor the solutions to a thoughtful, hierarchical social policy designed to solve the problem at all of its levels. In other words, we have to get out of our own way. So for me, when I think about this issue, I think about never since the Great Depression and the time of Hoovervilles have we seen homelessness as we do today. The big difference is that the end of the Depression, the Hooverville crisis was solved by putting people back to work. But ours isn't solved by that. Our problem is a much more complicated one that exists at the confluence of failed policy regarding severe mental illness, the birth of 1960s era social policy demanding individual rights and doing your own thing without a shared sense of personal or societal responsibility for its consequences, and political paralysis at both ends of the spectrum. If we do not solve this issue, it will keep getting worse, and it will cause problems for the housed and the unhoused alike. Homeless encampments lack basic sanitation. They're unsafe for homeless people as well as those outside of it. The pandemic shines a bright light on the worsening of the problem, together with drug-resistant TB, hepatitis A, and typhus that runs rampant in these communities. Children are being raised without access to stable education in environments risking personal harm and disconnection from society, contributing to the cycle. Homeless parents don't know where to go for help. They're frightened to reach out to social services to ask for fear of losing their children. Society has a special dislike for how it treats its veterans for whom the ravages of service have left them unable to re-enter society, or its elderly who finds that they're incapable of working any longer but didn't save enough to retire, or its foster youth who age out and join the ranks of the homeless with no social skills and no desire to gain them. It's severely mentally ill citizens who have nowhere to go and survive on the streets, jails, and emergency rooms, and disabled citizens who have nowhere to go but cannot support themselves. Now, the law tells us that we have to solve this problem or learn to live with it. So we're at a crossroads. From Martin versus City of Boise, we know we can't criminalize homelessness and insist that people not sleep or be human outside if there's nowhere else for them to go. But there is nothing, and that is nothing, that says that the solution has to be provided with traditional housing. There's no right to housing of any particular type. And we should accept that not all homeless people, indeed all people, not everyone wants a stick-built house, wealthy or homeless. Traditional housing cannot solve the needs of a whole segment of this population. Those, again, who are unable to follow the rules, either because of severe mental illness or narcotics addiction. There is a wonderful book and movie by Dr. Ken Rosenberg. And one of the examples that is poignant and touching is Todd. And Todd is a big man, and he's in his late 40s or maybe early 50s, and he's inflicted with a serious mental illness that showed up in his late teens. It causes him to devolve into terrible rages and paranoia. He's been homeless most of his adult life. He wants and needs a place to live. And after a few years, because his waiting lists are long, a social service agency finally finds him a single room occupancy facility, and he weeps with joy. But a few months later, he has a significant SMI, serious mental illness episode, resulting in his arrest in jail. And of course, he loses his apartment for good. And when he is released, he has nowhere to go. He has a history. And this plays out time and time again. So understand that there is no law that prohibits us from solving this crisis with minimally adequate situations tailored to the populations to be served, full-time, safe, with electricity, refrigeration, out of the elements, garbage collection, access to services. But the solution straitjacket that we wear that demands that all solutions be in traditional housing with plumbing rather than porta potties and so forth ensures that we will never solve the problem and quiets the voices of those who seek and are willing to do so. There's really no reason that a tiny house, an RV, a Quonset hut, or even a tent with services, electricity, communal porta potties, shared restrooms, shower and laundry trucks that come by, food trucks, can't solve this crisis, at least in the short term. And in fact, we used to take care of people. The turn of the century, and that is the 19th century and the 20th century, we used to take care of people. We had things that we called poor houses or poor farms or county farms. They were on an SRO, a single room occupancy model, where people work the farm, they produce products, that were used either on site or sold in communities for support. You found yourself there either voluntarily, some people went voluntarily, or by the petition of overseers. And overseers were people who had the power over you to force you to move. But really, we have overseers today, and they're called neighborhood associations, who call or file petitions with their local government that they have a homeless encampment, which then is dutifully swept or towed away, removed. And instead of having a place to go, the overseers of modern day ensure that a homeless person simply loses everything and has to start over. We can learn from our history. Was it perfect? Absolutely not. Were poor houses and almshouses and county poor farms terrible? Yes, they were. But the model of having a commitment to provide for people without the ability to take care of themselves is a worthy one. Perhaps we should decide what is minimally adequate and provide it. And perhaps we should revisit the idea of the county farm or the poor farm. But one thing is certain, we have to allow people to be housed in safe but adequate circumstances that take into account their circumstances within the budget of the working housed to afford. Housing policy cannot be tailored to feel-good outcomes for the housed that ignore their likelihood of success. And there's a fiscal opportunity to take care of this problem. If we would commit, there is money. No one, and that is no one, has ever studied, and maybe it's impossible to know, the real cost in the United States of homelessness. but we can infer it's pretty darn high because in 2017, HUD estimated, based on 2002 dollars, that each homeless person costs about $41,000. Santa Clara County alone estimates the cost of housing or homelessness to just that community between the years of 2007 and 2012 was $520 million a year. Whatever the true cost, it is high, and it hasn't provided any measurable or tolerable solution to this problem. It's time to think differently. So what do we do? My thesis is I do not believe that state or local governments can solve this problem. Politically entrenched zoning, rules, and neighborhood entitlements will take years to sort out. As part of a longer-term solution, we must develop, in conjunction with the advice of experts, a federal law that has a mandate that every city and every single state, big and small, in America has its proportional national share of housing for people who are otherwise homeless on particular timeframes, and maintain that housing for existing populations that come and go. They would be audited for compliance, and if they fail, the feds will step in and do it for them. The law would require two segments, an immediate one and a longer term one. It will reflect that there is no universal law that says a community of people cannot be housed in RVs, Quonset huts, tents, etc., so long as the community is properly sized so it doesn't become the projects. They are not concentrated in any particular part of town. They're distributed. They have sanitation, outhouses, hand washing, garbage collection would be minimums. Communal areas with refrigeration, eating spaces, electricity, and services scaled to the needs of the community served. Immediately, it will be possible to relocate tent sites, residential cars, and RVs to facilities that are frequented by social service representatives who target and are responsible to figure out and maintain needed services to those particular individuals. Longer term, whatever the community wishes to do, as long as it's consistent with basic minimums, would be within its right. The need for new facilities is reassessed annually. As homelessness is reduced, so is the need for such places. Everyone is incented to solve the problem. The mandate comes with federal money otherwise spent by the federal government on homelessness. And again, each city has the power to decide where they're going to establish the facilities and what it looks like. But they have to do so within a certain timeline with recognition of certain basic minimum standards that have to be provided. And keeping in mind Professor Robin Dunbar's cultural and human anthropological studies that shows human biology requires that we keep our groups small. So the community would be no larger than Dunbar's number of 150 people, which is the cognitive number of people who can live together and maintain stable relationships. Again, the idea being to avoid the projects. The law will include environmental smarts and environmental justice and forbid the creation of the projects or concentration of public housing in particular parts of town. It will reject the idea that homeless people do not deserve the same level of safety and law enforcement response as anyone else. The idea of a self-governing encampment should be a non-starter. No one should be expected to resign to live under a self-governing despot or despotic community. Society legitimately wants and expects otherwise homeless people to live in a way that is safe for all of us. Facilities for families of school-age children would be expected to be accompanied by excellent childcare, parent training, drug rehab, intensive supports, including IEP and 504 planning, educational support for kids, because most of us know that for housed people, the IEP 504 maze is beyond the ken of most. It is daunting in the extreme for a homeless parent. This may entail State and local governments condemning to buy nearby homes and commercial establishments to create a buffer for political acceptability. There may need to be a formula for distributing particularly difficult groups whom smaller communities simply cannot manage. Think pedophiles released from jail and the smallish group of people who simply refuse to follow any rules. They're capable, but they refuse. Once communities establish and maintain their housing, then it becomes unlawful to camp in unsanctioned public places, and that law is enforced. Each state must also have an adequate number of federally funded mental institutions where the SMI can be treated, and if they're untreatable, where they can stay until unsupervised or minimally supervised treatment is possible. Organizations with specialty in the unique problems suffered by the severely mentally ill will establish such protocols. Perhaps we prioritize public investments. Perhaps we establish SROs for veterans without school-aged children so they can have shared experience to contribute to a sense of community and success. Perhaps a youth hostel model for homeless youth, aging out of foster care with no social skills, that provide intensive targeted service in GED and college programs. Perhaps a similar model for elderly who have retired without savings. The list goes on, but I guess the message of my talk is the way to solve this problem is to apply the health and the legal and the human knowledge that we have to solve it and to commit to it. Otherwise, the path we are on will lead us to the result we have had. So thank you.
Thank you. So now we are moving very quickly to our Q&A portion. If all of the panelists would please turn on their videos. We're going to be assisted by McKenna Johnson, who is a student host. We already have one question that Professor Rosser has answered live, and McKenna Johnson is going to read the 2 remaining questions that we have right now.
Hello, thank you. Both questions are for Professor Alexander. First, who owns the underlying land on which these villages are located, the homeless villages? Does it matter for the purposes of housing the homeless? And that was from Bill Fischel at Dartmouth. And in combination, your second question from another attendee states, in regards to tiny homes, when does the right to exclude end? Suppose a person dies who is rightfully in a tiny home and has invited other family members to co-shelter. Is there any protection for the survivors?
So can you guys hear me? The host precluded me from putting my video on. So can I get my video permissions back on so you all can see me as well? But in terms of the question, the land is owned by different situations in all the different villages that I studied. In some cases, the land is owned by a church. In other cases, in many cases like Seattle, almost all of them are owned by the city. It's on city-owned land. And in other cases, like the one that's happening in Madison, Wisconsin, there was a nonprofit that the homeless individuals created, and that nonprofit owns the land. So it's very different in every situation. The one in Austin, for example, that's owned by a nonprofit faith-based organization that provides support. So it's different, and I don't think it makes a difference to the insights I provided, exactly who owns it, as long as whoever owns the land, right, is committed to sort of doing this and stewarding and working with the communities to support this for a long term, right? So that, oh, they let me start my video. Can you see me now? Yeah, okay. So I don't think it matters that much. And in terms of the right to exclude question, the idea is that you have the right to exclude. I think it doesn't extend to your heirs. So, but I do believe that because this is a real public-private partnership that many of these villages are involved in, that if there was a unit that was big enough to house 2 or 3 people and one person died and your heirs were there, that those community groups, the nonprofits, the people sponsoring it would work together to see if the individuals who are their heirs could still stay there. But no, you have no right to alienate this to your heirs. The right to exclude is specifically a right to use while you're alive.
So that's all of the questions we have, and also all of the time we have. The next panel starts at 2:15. So thank you all for coming. Please join me in virtually thanking our panelists, and we will see you at the next panel, the roundtable on emerging issues in takings and eminent domain law.